Good morning. So we're here in Raleigh, the capital of North Carolina. And we're about to provide service on the Supreme Court of the state of North Carolina on behalf of the affected parties and litigants here within the state of North Carolina for these indictment crimes. So when a state enacts its own alternative legislation and then substitutes it for the provisions that guarantees the Constitution, that would be an unconstitutional act. Obviously, state laws are not supreme or superior to the United States Constitution. So states do not have the authority to be able to enact their own laws and then substitute them and replace the provisions or guarantees within the Constitution. That would be unconstitutional. So we have a supremacy issue that must be addressed, and we have to deal with this. So we need to determine what is the supreme law and which one is going to be the one that mandates or dictates the requirements that have to be followed. So when a state enacts these laws, they're contrary to the Constitution, and then directs their agents to enforce them, that is a crime. It's deprivation of rights in color law, Title 18, subsection 242, which states any person who, under the color of any state statute, ordinance, custom, or regulation, deprives the person of any rights secured by the Constitution, commits that crime. Now, this is a per se crime, meaning we don't have to prove they intended to breach their obligation simply by virtue of the breach. All elements of crime have been met because their willfulness and knowledge derives from the promise they make. If you make a promise, you offer an oath and promise a certain future outcome, you must fulfill that outcome. If you don't, I don't have to prove that you intended to do it because you promised to do it. So these prosecutors, these judges, they all have an obligation to do what the Constitution of the United States says because they entered into oath or affirmation to do so. Now, a number of people have said that they take two different oaths. They take an oath to the state constitution and to the federal constitution. And I'll tell you, early on, I thought that could be the context as well. I thought, oh no, there's the problem. They're taking notes of two separate laws, and obviously that would create a conflict. But the problem there is that all of the state constitutions within the first article, they all subject themselves to the supremacy of the United States Constitution. For instance, the state of Washington, its constitution, Article 1, Section 2, says the United States Constitution is the supreme law of the land. So if the state constitutions are automatically placed in subjection to the United States Constitution, then it really doesn't matter what the state constitutions say because they've already subjected themselves to the supremacy of the United States Constitution. So even if you took an oath to two different constitutions, the state constitution has already placed itself into an inferior position to the United States Constitution, and as a result, your oath is still with the United States Constitution. That's what you must follow. You don't fall back on the inferior state statute to make a determination as to the outcome or the direction that you should follow. So when a prosecuting attorney relies upon an inferior state statute that permits them to charge by way of information, not by indictment, as required by Clause 1 of Amendment 5 to the United States Constitution for any capital or infamous crime, when they do that, they're depriving United States citizens of rights that are guaranteed and enumerated in the Constitution of the United States of America, and that is, as I said before, a crime. So when they commit that crime by bringing the incorrect charge against you, and then they go to a judicial officer and they ask the judicial officer to hold this person over or to have him arrested so that they can bring him to trial, that officer, the judge, has a duty responsibility to make sure that the power he exercises is consistent with his authority. If he chooses to exercise his power based upon someone else's abuse of power, then he himself is abusing his power. That judge is there to make sure that the proper documentation is in place. And when he fails to do so, willfully or negligently, he has thus established a conspiracy to deprive of rights by and between him and the prosecuting attorney. So now you have a conspiracy. Title 18, subsection 241, it's in place. Whether it's willful or negligent, it doesn't matter because the laws of criminal conspiracy doesn't permit you to breach your constitutional obligation. Because if you do it, you have just deprived a person of their constitutional rights. There's no justification for that, and there's no right to self-defense. That's why public officials have a per se crime, because there's no necessary finding of facts. We don't have to take them to trial, right, and have a jury determine whether or not they're guilty. Simply by virtue of the breach, all elements of crime have been met. And they have already implicitly invited punishment in the form of perjury should they fail to fulfill the promise. So when they say you have to have knowledge and willfulness, that is for the people. It's not for public officials. Public officials have no right to defend themselves against a criminal act. If you commit a violation of the Constitution, you are guilty of it the moment you do so. That's why the Constitution says that you will maintain your office while in good behavior, and good behavior is defined as the avoidance of criminal behavior. So the moment you engage in criminal behavior, you are no longer fit to continue your office, and you're thereby discharged according to the laws of the United States Constitution in particular. Which is why the crime of impeachment doesn't require a finding of facts. That's Article 3. Article 3 says the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in a state in which the crime is said to have been committed. Impeachment is the only crime that does not require a jury trial. Because the moment that they fail to fulfill the promise, the moment that they do not follow the Constitution, right, willfully or negligently, they have engaged in criminal behavior. Because perjury is the effect of failing to fulfill your oath, to fulfill your promise. So, if you don't fulfill the promise, if you fail to do so willfully or negligently, you are thus guilty of the crime of perjury, which means that you are no longer fit to continue your office because you are no longer in good behavior. So when that judge then signs that order, whether he knew it or not, ordering someone to be arrested without having the proper charging instrument in place, and then he hands it off to an officer. He says, "Officer, please go out and arrest this person." That officer has a duty and responsibility also to make sure that the power he exercises is consistent with his authority. If he chooses to exercise his power based upon someone else's abuse of power, then the power he exercises is none at all. You see, he can't just go out and perform an arrest unless he has the proper documentation to do so. If he doesn't confirm and make sure that he's got the proper documentation, then when he performs that arrest, he has just committed the crime of kidnapping because he did not have authority to take this person and hold them in an unlawful imprisonment manner. And this is a federal offense, Title 18, subsection 1201, kidnapping, because the victim is being held over for ransom in the form of bail. And any time that you have a deprivation of rights under color law, it occurs in conjunction with the kidnapping. Of course, we all know that the punishment as prescribed by law is death. So this is a very, very serious situation that we're in. And all of these judges all across North Carolina, all across the country, are all doing this. And so we need to go to their bosses. We need to go to the highest level. That's why we got to fight crime from the top down. We need to go to the highest judicial officers in the state, because it's not going to do us any good to go out and argue and say, hey, judges, you guys are breaking the law, because they already know that, guys. It's nothing new to them, right? But when we go to their boss, the highest guy in the state, we say, you know what? It's up to you. You tell me what position you want to take. Do you want to be a criminal and thus be responsible for directing all of these judges to all act criminally? Or do you not want to be a criminal and thus correct this behavior? So we do not have the power to prevent anyone from exercising their power. These judges are they're going to do what they're going to do. But we have the opportunity to be able to put them in a position where we allow them to make the decision on their own. Do you want to be a criminal? If you do, then continue down the path you're on. But if you don't, then you will return to the established rule of law and you will fix this problem. So when we go to the highest judicial officer in the state, the Supreme Court, and we provide them notice of this clear-cut, absolutely crystal clear act of criminal conduct by their agents, when we show them that, we provide the notice, show that it was served, then at that moment, that highest judicial officer is going to have to make a decision. And if he makes the decision to continue to do things as normal, that's fine. That's his decision, and we have to allow him to do it. But what we can do is we can show him that should he choose to exercise power without authority, he will be a criminal, and we're going to make the whole world know just how big of criminals these guys are. So they will remain criminals until they return to established rule of law, because a criminal is defined as simply one that transgresses the law. It doesn't matter if it's the Constitution, state statute. If you transgress the law, you are a criminal. And today, our country is being led by criminals. The whole justice system is being led by criminals. So we need to decide, or we need to give them an opportunity to decide, do you want to be honorable? And if you do, then you will immediately change this behavior of everybody that works for you. And if you're not honorable, then continue down the path that you're on, and we'll see what happens then. So we're going to head over there to the Supreme Court here in a moment. We're going to provide service on behalf of the Eisenhower family for the crimes of deprivation of rights under color law, conspiracy to deprive rights, kidnapping, and other crimes is ascertainable by the evidence on the record. We're going to ask the court to step up, discharge the duties of their office, to fulfill the promise that they made to the people of the state of North Carolina, and protect them against criminals that work for them. And if they do not, then at least we will have our answers, and we'll be able to determine our next steps forward. So thank you so much for following me. Thank you so much for all the support that you guys have given me. This has really been a blessing to be able to serve all of you, and I look forward to bringing about this major change that's about to come. So thank you so much. God bless. Hi, my name is Tanawah Downing, and we have federal litigation with the United States Supreme Court. We're needing to drop off affidavits here with the state of North Carolina. Now, The litigation is not with the state of North Carolina, it's actually with Washington State. You guys are not named respondents, but there are elements that the justices need to be made aware of before we go into it. Our hope with this is that the justices will immediately direct the judicial officers within the state to act in a lawful and constitutional manner, and that way we can mitigate any further litigation that would be necessary. Here is top page, certificate of service, my contact information on the inside. Here is the affidavit from the party within, signed by Ms. Eisenhower. You have any questions, ma'am?
Eisenhower with I-S-E-N-H-O-U-R?
No, it's Eisenhower, H-O-U-R, yeah, at the end.
Okay.
Yes, sir.
We had a blonde Bill Eisenhower used to work for.
Yeah, no. Nanette is her name, I believe.
Okay.
Nanette Eisenhower, yeah. Boy, this is like the I think this is the 31st state that we've served in the last 3 weeks. It's been just horrible.
Yeah.
Has been provided on the state of North Carolina at the clerk office here. The crimes of deprivation of rights under color of law, conspiracy to deprive of rights, kidnapping, and other crimes is ascertainable by the evidence on the record and was received by the clerk grant. Thank you so much. God bless. Thank you, sir. Good afternoon. We are here in Raleigh, North Carolina. This is the capital. Right behind us here is the North Carolina Supreme Court building. We just provided service on behalf of the affected litigants here within the state of North Carolina for this indictment issue. We served it on the clerk of court, Mr. Grant, and they received it. We're going to provide it as correspondence to the justices. So, when a state enacts its own alternative legislation and then directs its agents to follow the inferior state constitution that violates the United States Constitution, that would be a crime. So, Clause 1 of Amendment 5 to the United States Constitution says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Now that's clear. You must have an indictment by a grand jury before arresting someone and holding them over for a capital or infamous crime. Now, an infamous crime is defined by Title 18, subsection 4083 as any crime punishable by more than 1 year imprisonment in a penitentiary. So, if you can get more than 1 year, it would be an infamous crime. Now, it's not the amount of time that you get sentenced to, right, that makes it infamous, but rather the amount of time you can be sentenced to. So even if you only get 3 months, and yet you could have gotten 3 years, it is still an infamous crime. Therefore, it still requires an indictment by a grand jury before arresting you and holding you up. Now, these states, including the state of North Carolina here, they feel as though they can charge by way of information and not by indictment by the prosecutor's discretion. So they've enacted their own alternative legislation, and then they've substituted it for the provisions and guarantees of the United States Constitution, thus permitting the prosecuting attorneys to use their discretion abusively to violate the law and breach the Constitution of the United States. Well, Section 1, or Article 1, Section 10 of the Constitution of the United States says, no state shall enact any law that shall impair the obligation of contracts. So when a prosecuting attorney enters into his office, right, he promises a future outcome. That's the oath. He promised to fulfill a future outcome, and that outcome can be defined by the terms of the contract. That is a contract that prosecutor's made by and between people to perform in a certain way, follow certain rules. So when a state creates a law, right, that impairs the prosecutor's ability to be able to perform their duty as required by the Constitution, that would be an unconstitutional law. States may not create any law that will impair the obligation of contracts. So the contract between judges, between prosecutors, that is by and between the people, and the terms of that contract are defined within the Constitution of the United States. Just like it says in Article 6, the judges in every state shall be bound thereby anything in the Constitution or laws of the states contrary notwithstanding. So even if a state creates a law that directs a judge to act in a different manner, their oath is still with and to the Constitution directly. It's not with the state. So the terms of their contract, their performance criteria are defined within the Constitution of the United States. And when they fail to fulfill those obligations, when they fail to follow them, willfully or negligently, they're guilty of the crime of perjury immediately. They're guilty of the crime of deprivation of rights under the code of law. So we have a pretty major situation here where across the United States, there are more than 700,000 people currently in prison today that never received indictment by a grand jury, despite the fact that it's required by the Constitution of the United States, because these states feel as though they can act in their own manner, whatever way they see fit, and adjudicate crimes whatever way they want. This is direct willful defiance of the laws of the United States and the laws enacted by the people. So these states need to understand that when you create a law that is unconstitutional, right, contrary to the Constitution, and then you start performing and directing your agents to act under that unconstitutional law, then everything you produce is going to be unconstitutional. Because any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. So every single thing that North Carolina is doing right now is, unfortunately for them, unconstitutional, because they're failing to recognize and follow the supreme law of the land. So the Constitution of the United States is the supreme law. I don't think that any one of us will ever question that. However, when the states tell us that they're going to do things the way that they want to do it, that is an act of sedition. Sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection of the Constitution to procure its alteration other than lawful manner. There's one way to change the Constitution, and that can be found within the special amending procedure of Article 5. It has nothing to do with the state enacting its own law and then imposing its will upon the rest of the nation. It has nothing to do with the judicial branch. It has nothing to do with the executive branch. It must be done by an authentic act of the people. And until that's done, those guarantees are sacredly obligatory upon all, individually and collectively. They will not change, they do not change, and no state can take them away. So we just provided notice to the Supreme Court of the state of North Carolina through one of its agents, the Clerk of Court. So having provided notice to the Supreme Court, those justices now have a duty and responsibility that they must take action, lawful action, in courts of law. And if they fail to do so, then they will become complicit in this criminal conspiracy, and they themselves will become traitors themselves. So the laws of criminal conspiracy state any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined as defendants in the action. We all know that the Supreme Court has the ability to take action and correct this behavior. We all know that they are responsible for all the judicial agents within the state. They're working for them. So under their watch and under their authority and their direction, all of these judges are committing major crimes that are punishable by death. And so that Supreme Court, they need to make a decision. Do they want to be known as criminals? And if they do, then continue business as normal. But if you don't, if you want to be honorable and you want to be leaders, then you will step up, you will discharge the duties of your office, you will fulfill the obligations and promise that you made to the people of the state of North Carolina, and you will hold criminals accountable for the crimes they commit. It doesn't matter if they work for you or not. We don't care who they are. We don't care what position they hold, what office they fill. A criminal is a criminal. Anyone who transgresses the law, doesn't matter what the law is a criminal. And right now today, our country is being led by criminals, and that's what's causing mass discrimination, mass incarceration, because we're simply following our leaders. So you guys need to step up. You guys need to do the right thing. You need to act honorably, or you need to get out of there, because we're done lying. All right? We're done calling you honorable. So Justice Hugo Black stated in 1960, honorable men honor the law. And you guys, not one of you, are honoring the law. So it's time for you to step up, do the right thing, and enforce the laws of the United States. It doesn't matter how big this issue is. It doesn't matter how long it's gone on. You guys caused this, not the people. So you guys are going to fix this. You're not going to continue to oppress the people and operate in violation of the very laws that create your office, grant you your authority. When you violate that law, don't think that it's going to protect you. So thank you so much. And I pray that you guys are going to do the right thing here. God bless. Have a great day.
I paid all my payments, I'm all out of patience, so save all your statements you say from your basement. I stand on the pavement and fight for my people against you dictators.
Hear the cries of the crusaders, show them what we're made of. I put my armor on. Hear the cries of the crusaders, show them what we're made of.
I stand for what's right. Even if I stand alone, I'd rather be losing this battle than winning while fighting for something that I know is wrong. Known all along, I have a purpose. Gotta reach reach my people. Ain't no common ground on the battlefield that we're standing on. It's a war going on of good and evil. I'm a crusader. Screaming my prayers, I'm hoping that God hear my word and find favor. Speaking my truth and my tongue is a razor that open the